Hi, my name is Vicky Kimbrell, and I'm the Family Violence Project Director with Georgia Legal Services. I'm here today to talk with you about family violence protective orders and walking through that statute so that either you or someone you assist can get a family violence protective order. We're going to talk to you about how effective protective orders are. Did you know that in 70% of the cases, a family violence protective order will end the violence or substantially reduce the violence? Protective orders aren't for everyone, but when you believe they can provide help and assistance for you, they're an effective tool in stopping the violence. Now I'm going to go through the slides that talk about the Georgia law on family violence and how you obtain a protective order under the statute. We're going to talk today about the family violence law in Georgia and practice. Georgia Legal Services represents clients in 154 of Georgia's 159 counties. We have 10 regional offices across Georgia in the larger cities such as Augusta, Columbus, Gainesville, and Macon. Our areas of practice include, but aren't limited to, family law, consumer law, housing, education, benefits, and health law. We do not provide any representation in criminal cases. So this morning I'm going to talk to you about the Civil Violence, Family Violence Protective Order law and the procedures you use to obtain a civil protective order. The statute that you're going to be using to obtain a protective order is called the Family Violence Act. Who can obtain a Family Violence Act protective order in Georgia? You must meet two tests to be entitled to a protective order. There must be a specific relationship between the parties, and there must be a specific type of violence. The relationships include present or past spouses, parents of the same child, persons living or formerly living in the same household, parents and children, foster or step-parents, foster or step-children. What type of violence qualifies under the Family Violence Act? The violence must be a felony, a battery or simple battery, assault, simple assault, stalking or a pattern of stalking, criminal damage to property, unlawful restraint, or criminal trespass. There are certain types of abuse that are certainly family violence, but are not covered by the Family Violence Act. For example, coercive behavior or psychological behavior is not covered by the Act. This could include all types of emotional threats as long as they do not include a threat of violence. Verbal abuse is not covered under the Family Violence Act. Economic control is not covered by the Family Violence Act, or isolation of the party unless there's some sort of physical abuse included. This does not mean this is not family violence, just that it is not covered as defined by the statute. Jurisdiction is whether or not the statute allows the state of Georgia to take jurisdiction or control over this action. Jurisdiction under the Family Violence Act is covered under 1913(2) under the statute. Jurisdiction for a Family Violence Act includes 1. When the abuser resides in state. If the abuser resides in the state of Georgia, jurisdiction, or where you can sue, is in the Superior Court in the county where the abuser resides. When the abuser resides out of the state, jurisdiction is in the Superior Court where the victim resides or where the abuse occurred. A person who is not a minor may seek relief, that is, the court would have jurisdiction, but only when the minor has someone filing on her behalf. So the question is, what is the proof of violence? Proof includes sworn testimony, medical records, medical bills, police records, detailed reports. Police records are required to be filed in every family violence case. Proof or evidence can also include witnesses to the violence. You can also have expert testimony, people who are experts in domestic violence to testify. And the best evidence in any case are pictures. Photos, police photos, hospital photos, agency photos, photos that you take or that a friend or a neighbor takes. Today, there are often many circumstances where social media is part of the family violence case. We have time after time where threats of violence are made on social media. So we warn people to keep and to maintain all of the evidence that you obtain through social media. We also warn people not to be part of anything that is going to adversely or badly impact your case. For example, you don't want to put anything on Facebook or Twitter or email that can be used against you in a case, in your custody case or in your Family Violence Act case. One of our sayings is, don't put anything or don't write anything down you would not want your mother to see, because abusers can use and try to manipulate anything that you say, anything that you put down in a computer can be used against you. So be very careful about what you put in your social media. So what can you ask the court for in a Family Violence Act? You can ask the court to restrain or stop the abuser from abusive acts. You can ask for possession of your home. The most important thing that most of my clients come to us about is custody of their children. You can ask a court in a protective order case to award custody. You can ask the court to remove the abuser from the home, or you can ask the court to set visitation and child support in a custody case. You can ask for spousal support or personal property to be awarded, and you can ask for fees or attorney's fees to be awarded. In every case, an abuser should be ordered to a family violence intervention program. And finally, and one of the most important issues in family violence protective orders is to ask that guns be removed from the batterer. So the first question clients ask is, why would someone want a protective order? The first reason is because a protective order dramatically improves the likelihood of law enforcement intervention. Subsequent violence after a protective order can result in a felony charge of aggravated stalking. And again, protective orders can award custody for up to 12 months and can assist the victim in establishing financial stability. Finally, in a protective order, you can ask that the abuser's access to firearms be limited. And the evidence shows that in 70% of the cases, the family violence is stopped or substantially reduced by a family violence protective order. So why would someone hesitate to file a protective order? Well, a lot of times the victim is not sure that she wants the relationships to end. A lot of times the victim does not want to testify in court. Nobody wants to go to court and have their most personal and secretive moments set out in a courtroom. Sometimes the victim wants to keep her location confidential. And some victims are just afraid that the firearm restriction would make an abuser more likely to use a firearm against them. That's why the ultimate decision on whether to file for a protective order is always up to the victim. So assuming the survivor does want to file, what are the procedures for filing for a protective order? A verified petition must be filed. That means that the survivor is testifying to the truth of anything in the petition. The petition must be based on facts that probable cause exists, that family violence has occurred in the past and may occur in the future. The respondent must be notified by being served with a copy of the petition, and a hearing must be held no later than 30 days after the petitioner is served with the pleadings. The petitioner then goes to court and must prove the allegations of the petition by a preponderance of the evidence. If the hearing is not held within 30 days, the order must be dismissed. The statute was recently amended to allow for an additional 30-day extension on the agreement of the court. And finally, orders can last up to 12 months or can be made permanent upon the petition of the survivor. How, if in fact you get a protective order, will that protective order be enforced? Civilly, protective orders are enforced by an action for contempt. You can file an action for child support noncompliance, and there are compliance hearings that the court can schedule on their own. Protective orders cannot be modified by the conduct of the party. Only a court can modify or change or void a protective order. Mutual restraining orders are prohibited without prior notice. The abuser can go into court and ask for a protective order, but only if the respondent has filed a verified petition no later than 3 days prior to the hearing. Georgia's protective orders are now sent into the Georgia Protective Order Registry. You can have a foreign protective order. It contains protective orders, and law enforcement and judges and district attorneys can look up on the registry and determine whether or not a protective order has been entered. Divorces, however, are not included on the registry at this time. The registry is why we have standardized orders, so that they all look alike and so that they all can be on the registry. If you use Georgia's standardized forms, these orders are also entitled to full faith and credit in other states. They have the appropriate language that implicates the Brady-Gunn Act, and they also require that they be enforced by the stalking statute. The Brady-Gunn Act is a federal law that prohibits a person who is subject to a protective order from possessing a firearm while the protective order is in force. The protective order can be issued after a hearing of which the respondent has notice and opportunity to be heard. The official use exemption, however, allows certain government employees to still have access to a firearm if they are in fact on official duty. This does not apply to any criminal actions under the Family Violence, but only applies to the Civil Family Violence Act. So this is the end of our first module that talks about the Family Violence Statute. Look at these questions and think about if you can answer these questions after this presentation. So let's talk about those 3 questions that we were just asking. The first one has to do with jurisdiction. In which county does the victim file for a protective order? The basic jurisdictional answer is you file in the county where the abuser resides. So if you are in County B, but the abuser lives in County A, you have to file where the abuser resides. The only exception to that rule is when the abuser resides out of state. In that circumstance, you can file where the abuse occurred or where the victim lives. The second question is, does the statute protect you if the abuser fails to provide food or shelter for you and your children? The answer to that question is no. The family violence, that is certainly family violence when someone is trying to economically abuse someone or economically isolate a person. That is certainly family violence. But it is not family violence that would be covered under this statute. The statute would only cover when there is violence or an actual threat of violence. And finally, the last question was, can the abuser be ordered to turn over weapons? And the answer to that question is absolutely. The Family Violence Act and the federal law requires abusers not to possess firearms and ammunition after a protective order is entered. However, in many cases and in most counties, you're going to need to make a special request and ask for the abuser's weapons to be removed. Thank you.